Yeah, perfect. So yeah, please go ahead. Sonalakshi, Anushka, Sanjana, all yours.
I think we're going to let Sanjana start this off because she was the one who was the first one in the whole process. So she will be able to give us the whole background of the zombie tracker in a very good way. So please, Sanjana, take it over.
Hi, yeah. I'm Sanjana. Me, Anushka, and Sonalakshi work at the Internet Freedom Foundation. So what we're going to talk about
Just
today
1 second. Sanjana, your voice is really low.
just movement. Is it better now?
Yes.
Yeah. Okay. Perfect. Yeah. So we're briefly going to be speaking about the judgment that led to the zombie tracker, after which Anushka and Sonalakshi will explain the project in greater detail. So the judgment that led to this project is Shreya Singhal, which all of you may be broadly familiar with. When the judgment came out, I was in law school, and I'm also going to talk a little bit about my perspective on judgment such as this has shifted so much since I was in law school. Before I speak about the judgment, I think assumptions that we make in law school is when the judgment came out as a media policy nerd, I remember reading it cover to cover and assuming that everyone was aware about it. But a majority of internet users, our friends in other fields, etc., don't necessarily have the awareness of the laws that impact them. So that was one. I think that when you interact with law students and don't have as many non-law friends as you hope to have, you just assume that there's a greater impact of the law than there actually is on the surface. The second is that you expect some sort of immediacy to the impact, that once the Supreme Court said something will happen, that's the highest court in the land and everything is solved. So it felt like when Shreya Singhal came out, it felt like the end game in a struggle that had been ongoing for quite some years. It started with Facebook posts about politicians, etc., and arrests kind of across the country. Under Section 66A of the IT Act, Section 66A criminalized offensive messages and failed to define what offensive is. So we saw like a wide variety of people being incarcerated on the basis of messages that they'd posted online. So, I mean, ranging from West Bengal to Maharashtra, etc. So a variety of petitioners, including Shreya Singhal, who herself was a law student at the time, came to the Supreme Court. And as all of us know, Section 66A was struck down. Now, I think one thing that we have to consider when we're looking at this is that it's a very bold judgment in that sense. So the judgment considered that offensive was too vague to be saved by courts. So what courts usually do is they can either strike down a provision in entirety, which rarely happens, or they can read it down, which is what we've seen more often. So for instance, sedition, which still remains in the books of law, was read down by the Supreme Court. So ideally, you kind of anticipate issues with something like that a police officer will not know what free speech standards to apply. So the provision for sedition remains on the book, even though there has been some constitutional standard applied to that. So when Shreya Singhal came out, it felt really bold because not only was it the first major judgment on the right to online speech, it also struck down the judgment in entirety. So as far as anyone could see, there had been this battle that was ongoing for years, which culminated in 2015 in a Supreme Court judgment striking down the provision. The implication of a provision getting struck down in law is that it is considered stillborn. It is as if the provision never came into existence in the first place. And as far as anyone was concerned, that was the genesis of the internet movement in India. That was the beginning of people being aware of their rights online. That was probably the most significant free speech judgment of the century. So it felt like a win-win to everyone concerned. And in all ways, the story should have been over there. except it wasn't. So a couple of years later, newspaper reports started emerging of um, arrests being made under Section 66A. Then Internet Freedom Foundation wrote a paper on this, authored by Abhinav Sekhri and Apar Gupta, and they called it the legal zombie. So this provision, which was supposed to be stillborn, as if it had never existed, or at the least a provision that had died its legal death in every way imaginable, kept coming back. So even though the provision no longer existed on the books of law for all purposes, it kept being used in arrests in UP, in even in cities like Delhi, which where you imagine that there is greater awareness. They found that not only was the provision being used in police stations where police cases are being registered against people, very often they would actually even go to court. So there were court decisions which referred to 66A. We saw cases for quashing, which means that someone A had the awareness that the provision is unconstitutional, B had the amount of legal help that it takes to go to a high court and get that prosecution quashed. But we saw like a variety of judgments across district courts in Delhi and across high courts where the provision was being referred to. Quite surprisingly, this happened even at the Delhi High Court, where someone wanted to censor Netflix. So they filed a petition before the Supreme Court saying, regulate all this content online, before the Delhi High Court, I'm sorry. And the Delhi High Court, in fact, actually said that we don't need to frame a law because Section 66A already exists. And this was in 2018, 2019, when like the provision has been struck down by the Supreme Court 3 years earlier. So this was not a mistake that you or I were making. It was a mistake that the Chief Justice of the Delhi High Court was making. This was, however, subsequently rectified. So what the problem seemed to be is that the Supreme Court makes a decision, but there is a signal gap between the decision of the Supreme Court and the ground reality. So PUCL, who was one of the original petitioners in Shreya Singhal, was approached by Internet Freedom Foundation. At the time I was working with PUCL, I was working with Sanjay Parekh, who's vice president of PUCL. So IFF showed this paper to PUCL, and then as there was a collaboration between PUCL and IFF, and the decision that we took was to bring this to the notice of the court. So we filed what is called an MA. It's a miscellaneous application which kind of revives a dead matter. So if you need some further directions in a case which has already been disposed of, then you file an MA. So we'd filed an MA in the Supreme Court. Reviving dead matters also takes a lot of effort because the registry destroys all papers of all matters a year later. So, if you didn't have that old dusty file in your cabin, all records of Shreya Singhal have effectively been decimated by court registries. But when the matter came up, the court passed eventually, after 2-3 hearings, a bunch of directions, which included that the copy of the judgment will be sent to all high courts in the country. The high courts in turn will send it to all district courts and ask them to take appropriate steps. The second direction which was given is for it to be circulated to the Home Secretary of all state governments, and that in turn, it will be passed on to police stations by the Deputy General of Police. This direction, apart from what actually happened in court, there were also developments during the course of the litigation. So one thing that the paper had noticed is that India Code, which is the official text of the IPC, still carried Section 66A without any footnote or explainer that this has been struck down by the judgment. During the course of hearing, on their own, India Code updated footnotes for Section 66A and Section 377, which was struck down in the Navtej judgment. However, there were still other provisions in the IPC for which they had not made these clarifications, including adultery, some of which have been rectified now. Apart from this, during the course of hearing, the union government, when they filed their reply, had sent letters to all state governments. Some states responded, some didn't. But for instance, Kerala came forward and said that we have 19 cases right now. 4 are at the stage of investigation. In 15, we've already filed charge sheets, but we'll take appropriate steps to close all of these down. So this was impact that was incidental to the court litigation. And you could see here clearly that the problem seemed to be lack of awareness. So for instance, when Kerala was made aware that Shreya Singhal existed and that they had to take proactive steps to prevent something like this, they responded swiftly. So as far as we could tell, we'd once again reached a point where we thought the Supreme Court has passed directions and we thought that the problem has been solved. But at some stages, you realize that, again, as lawyers and law students, we think that the law is the solution, but we also need to start learning to collaborate with other civil society actors. And I'm sure as you're realizing during the course of these weeks, the significance of people who work with data in when we're tracking the implementation of laws. So even after the second order, which maybe Anushka will speak about some more, we realized that there were still prosecutions that were happening under Section 66A. Anushka, do you want to explain the tracker at this stage?
Yes. Firstly, I'm just
Anushka, before we go there, if anyone has, first of all, it was probably one of the most brilliant stories that I know. Like very, very revealing. But anyone, if you have any questions or any thoughts or comments that you want to ask like Sanjana about, like feel free to unmute yourself and ask if that's okay, Anushka, and then we can proceed to the other parts as well. Yeah, Nikhil, unmute yourself because it's very difficult for me to see your hand. Just like unmute yourself and ask question. Yeah.
Yeah, sure. And a Saturday evening, I just woke up and realized, oh, what is buzzing on my phone? Okay, this is the Zoom call which is due. So great start, Anushka. I just wanted to ask, this is something what happens, post passing of the judgment, right? But something that is in the making, or is it already done? I am not sure, but there's something called as, pre litigation impact assessment sort of things also. So there's something going on like that also, before passing of the legislation. There's an assessment which can be also done, like the impact of it. This is very specific to a judgment, or its legal awareness. And then rightly said, whatever judgment the high courts pass, it does not drill down or filter down to the lowest levels, and still the lowest authorities still keep on catering to the old provisions which have been struck down. But in my understanding, like there are some pre-legislative assessments also which are going on, which need to be done. So how is data interplaying in that sort of scenarios? Like this is very judgment specific, like at the larger ways in which data can play out its role. Like I think even Niti Aayog suggested something of this sort of using data for LIMB, LIMB, I think legal impact management system or base or something of that sort, wherein the case management system can be filtered out and the burden of the courts can be reduced. So are we talking about this zombie tracker is very specific to tracking? Because I missed the context which Saurabh had said in the beginning. So if I've missed on something, you can just...
Yeah, I think the zombie tracker, I mean, you may have greater context after Anushka discusses it. So we haven't gotten to that yet. So far what had happened was the background story of the litigation before the zombie tracker. And the original paper that Apar and Abhinav wrote for IFF was also based on data that they could scrape. So this was based on searches on SCC and Indian Qanun, like data that is more accessible to us as lawyers. And so, I mean, all of these declarations were made that as lawyers, we have limited capacity. So this is the cases that we are aware of, but there must be like a lot more cases which are going on. As far as your other question is concerned about the impact assessment, I don't think there's any formal way in which this is conducted in India at this stage, whether it is this pre-legislative consultation, but that's not an empirical exercise. That's when people come and give comments. As far as judgments are concerned, the impact of judgments is not monitored at all, except in cases where the Supreme Court has what's called a continuing mandamus, where they monitor these really honestly whimsical judgments over time, and like just keep passing fairly different orders. In general, there's actually no way in which the impact of a judgment is monitored, especially in cases like this. Once a provision is struck down, we stop collecting data about it entirely. So ordinarily, for example, the National Crime Records Bureau would tell you how many cases have been prosecuted under any provision of the IPC or any criminal law provision of the IT Act. But because 66A was struck down, after 2015, we have no official data, because the police also assumes that the provision no longer exists. The people who are collecting data also assume the provision no longer exists. So they stop collecting data about the provision. So it's a complete vacuum in even the kind of like limited sources of data that we do officially have.
So how is it right now? How will the impact of wrongful or maybe misuse of these provisions be assessed?
Nikhil, should we take this question after Anushka and Sonalakshi has done?
I think once.
Yeah, I think they'll answer it. I think I have jumped the gun maybe.
Yeah.
I think once both Sonalakshi and I have spoken, it will be more clear.
Yeah.
Vidit also has his hand up.
Yeah.
Which is, if your question is not specifically about litigation to Sanjana, maybe you could just wait and then we can at the end have questions about the zombie tracker itself.
No issues.
Thank you. I'm just going to speak a little bit about the study itself. So Apar Gupta, who's the executive director, and Abhinav Sekhri, who's currently the North Council at IFF, they in 2018 came up with a study which was called Section 66A and Other Legal Zombies. They came up with this zombie terminology. They thought it was funny. And the study highlighted the continuous use of Section 66A, specifically that new cases were being registered at police stations, they were being investigated and even considered by lower courts. And like Sanjay said, even higher courts were not aware that Section 66 has been struck down, so it should not be considered. And in the study, as Sanjana also mentioned, they also highlighted the signal failure, which is the failure of the executive, the legislature, and the judiciary to respond to the judicial development. What this means basically is that the executive should have said that this provision has been struck down, so the police should not have been using it. The legislature should also have come up with an amendment to the act and said that this has been struck down, should not be there in the provisions or in the act itself. And the judiciary, obviously, with the district courts and the higher courts still hearing cases on Section 66A. So it was like a total signal failure from the top down. So the Supreme Court, even though the judgment came, there was cases still that were happening. This also highlights the importance and challenges of monitoring and ensuring compliance with the final decisions of the Supreme Court, like Sanjana mentioned. And it was because of this that IFF came up with the data-driven and evidence-based project that was Zombie Tracker, and we did it with Civic Data Labs. The objective of the tracker basically was firstly to monitor existing cases registered under 66A, to drive evidence-based advocacy through qualitative and quantitative research, to enable better citizen engagement with institutions of governance, to spread awareness around the continuous use of unconstitutional provisions, and to engage with communities through the platform to ensure that individuals are made conscious of their rights, and specifically that they can't be prosecuted under 66A because it had been struck down. What the tracker basically did was that we tracked cases under Section 66A at the district level between 1st January 2008, when the section first came into force, till 15 February 2020, which was the date that we decided to cut off. And that this was the time frame that we picked. And we did it only for 11 states, in which we thought that internet density is higher, and other factors that Sonalakshi is going to speak about. And we source this data from the eCourts website. Sonalakshi is going to throw more light on the data mining process and what actually went into getting the data and cleaning it, etc. But at the end, we were able to find out that there were still 799 cases under the section which were ongoing. The basic aim, and this is the last thing that I'm going to say and then throw it to Sonalakshmi, the basic aim or the basic goal of the tracker is to ensure that the use of this provision, which is unconstitutional, but which refuses to die and keeps coming back like a zombie, is stopped all over the country. That is what we want to achieve through this project. Sonalakshmi.
Hi, so thanks, Anushka. I'm Sakshi. I was a research intern and working on the Zombie Tracker project. So as Anushka said, we were using the eCodes website as our main database, and we were using their API, which Data Lab was helping us with, in order to get out the information from the eCodes website. One of the first things we noticed is that if you enter the eCodes website, there's various ways to search for cases. So one of the easiest ways for us to do that was to go to a specific act, that was the Information Technology Act. And then further, we could filter it out by section and put 66A in there. But when we did that, we saw there were quite a few number of cases as to what we actually expected, comparing it to earlier results from media articles or from our paper as well. So we did a small search just using the Information Technology Act without filtering out section 66A and realized two things. The first is Information Technology Act in itself was written in different ways. You had some which were all in caps. You had some where each word had the first letter as a capital, or there was no 2000 with one. One had Information Technology Act 2000 amended. So if you go on the website that's in the chat box, in the methodology page, you find a description of the various ways this one act was written on this website. So we had to go through each of those iterations, first of all. The second thing was, for 66A itself, I found it was written in various kinds of ways. So 66A was also referred to, sometimes they use 66 subsection A to refer to 66A. There were various typos, so you would have A, B in one instance. And when this happens, it does not filter in on the main search when you filter in through a section. So at that stage, we decided to first mine data from all cases which have any iteration of Information Technology Act from the eCodes website. While doing that, we found over 1,000 variations of acts and sections, and that's quite shocking considering there's about 30 charge provisions in the act itself. So that was the first thing that we did. The second thing was we chose a few provisions from the Indian Penal Code just at random, but some which we thought would be related to offensive speech, such as 295A, which is hurting religious sentiments. And when I went through that record, I saw that some places, even though your judgment included a reference to 66A that the accused has been charged with it, the eCodes website itself did not tag the case as a 66A case. So because of that, we then also find cases relating to certain IPC provisions, even though the eCodes website did not explicitly tag it as including a charge under the Information Technology Act or even 66A in particular. Once we had these cases downloaded, the second problem was the incompleteness of data. So a lot of these cases were disposed of, but we couldn't find what actually happened because there were no judgments uploaded, there were no details as to what actually happened in the case. So some of them might have been dismissed, or even if they were not, there's no indication on the website as to what's happening. The only thing we could see was whether it was an active case or a disposed case. So on the tracker, any case that's active is a case that has not been decided yet as tagged on the eCodes website. And any case disposed of, we're not sure if the charge was dismissed, is included in the case disposed. Because of the lack of judgments, it was quite difficult to find out where there were typos in the tag of the section as to whether they actually refer to a section 66A tag. An example of this, I'm just going to type it up in the chat box, is if you have something like 66AB without a judgment, we couldn't say whether this was what was actually meant to be, because 66 small subclause A was not a charging provision, and we didn't know if this referred to 66B, whether it was a typo, whether it meant 66A and 66B. So we had to discredit these cases and move them from our final count. This is so that we didn't have a false positive. So for the numbers around the website, we do know that these cases were certainly 66A because either they are explicitly tagged by the eCodes website as 66A, or because even if it's not explicitly tagged, they have had a judgment where we could go and read that this is happening. So we use that to get out the minor data, filter and clean it in order to get the numbers and create the graphics you see on the website. And yeah, Anushka, is there anything else to be added about the internet penetration or?
Not really. Maybe you could talk about how we selected the states and why we.
Yeah. So initially there were only 7 states selected, but we didn't have, because of this problem with the non-standardization and incompleteness, we didn't feel we had a good enough data set. So we decided to expand to more states, and what we learned from the first 7 states were that states which have tier 1 or metro cities were more likely to have a better digitized e-code system. Now, it might not reflect it for the entire state and might be only for that city, but it was one way for us to ensure we had a good amount of a good database from which we can conclude our hypothesis. Thank you, Anushka, has put in the list on the chat box. And if you see the list, we try to have a good mix of large and smaller states just to ensure it's reflective and we don't have a very skewed database in that regard.
Thanks, Sonakshi. That was great. I was hoping Apurv could also talk about the process a little on the CDL side. I know Apurv is on the call. I saw him. Yes.
Yeah. Can you hear me? All right.
Yeah.
So, yeah, I think Sonal actually covered most of it in terms of the challenges, and though this looks like something that data is readily available for, especially after. So, as in if we were doing this project, let's say 2 years back, 3 years back, even this would have been. I don't think this would have been possible. So we are able to reach there. So that's a success or an evolution, whatever you can. But still, we are far away from like making these things or making this research possible by like a lot of different stakeholders. That is when I think things will change. So I think this is if one of the other things that we are trying to do is collect more evidence. So obviously collecting evidence around there are cases being registered, but also collecting evidence around what are the challenges that we face while in terms of accessing this data. And people who are building the eCodes website or who are working on building up this platform, so we can take this evidence to them and say, okay, we kind of did this exercise for just 11 states, and we took almost a year to just get access to that data. So forget about the research, forget about the other things we'll have to spend time on. So why is it so difficult to get access to this data? Why is data not stored in the right standards? What are the challenges? And there are very the challenges is we can solve them, but obviously if we don't know about them, so what eCodes is trying to do also is every state has its own different practices of recording or storing legal data. So eCodes is also trying to standardize that across the country, and there are a lot of challenges in doing that. So I think the more we are able to do this sort of a work, the more we are able to build use cases around why and when the data from eCodes can be used. I think it will only help improve the system. So yeah, I just wanted to add that part, but yeah, I think there is a long way to go. We conducted this exercise for just 11 states. I think majority of the country is still left, and we also were able to do this just as in the data you are seeing on the website or the tracker right now is updated till February of 2020. Sorry, February of this year, I think. So if we have to, keep a track of it, we'll have to keep updating it periodically. That is another challenge we are facing. So yeah, so these are again some of the challenges, but and I think probably Anushka will add more. But recently we've been able to get in touch with the E committee, uh, just to see if how they can help us and how we can help them. But I think Anushka can share more on that part. Yeah.
Yes, I think Apoor and my colleague Tanmay, who's the Associate Litigation Counsel at IFF, they got together and they wrote to the E-committee about the issue with the E-courts, and we're still waiting to hear back from them. But yes, Apoor did highlight one of the major issues with the E-courts website is that it is very problematic how we're not able to access data, and transparency in general is extremely important when it comes to these situations. So this is something that also is included in our recommendations. So Nalakshi, if you could just quickly give the three recommendations in gist, then we can get to the questions.
I'm just going to reply to Saurabh's question on the chat just before that. So currently on the tracker, we see that for entire time period that we've conducted this project, for about 2,000 cases were registered in this period. But this is after we have filtered out cases which may have been 66A, but we weren't sure, as I said, because of the lack of judgments that were available on the eCourts website for us to confirm this. So basically, in regard to recommendations, you can probably read this in further detail on the Zombie Tracker website. And we split into three main categories. The first was about section 66A in itself. Because our project shows that there are still about 700 cases that are still charged and outstanding under this provision. And we pointed to about a couple of reasons for that. The first is, like Sanjana was saying, the main barracks which are present in many of the police stations still have section 66A. So in order to remove 66A from the Information Technology Act, the legislation needs to pass an amendment to do that, which they haven't done till date. The second thing is about the executive action. We've been told that these directions were given out to home secretaries and they had to pass it on. But the fact that we still have so many cases at the ground level shows that this in itself is not being done. The second thing is about the eCourts website in general and relates to the two main challenges that I told you. The first is non-standardization and the second is incompleteness. With non-standardization, I think like Apoor said, each state had its own policy, and the kind of differentiation we see in writing the same act makes me, like, I believe that the field where you upload the data is a free text field rather than a drop-down list. And if that were put into a drop-down list, the person entering the data would select one format of the Information Technology Act. And similarly, if for sections there was a pre-coded list, if section 66A was struck down, they could just remove that from the main site. So no one would be able to select section 66A while uploading a case. Or if they were able to select it, it could tell the person entering the court data that this section has been struck down. That might help alert people to this. The provision has been struck down, even though there is an official amendment yet to remove from the act, or maybe message has just not been passed through due to, like Sanjana said, signal failure. And I think the last point that made a recommendation was the general duty of the high courts towards the district courts in their jurisdiction, and how they perhaps failed in that duty to ensure that of this provision, the district courts, their jurisdiction, have not been complying with the judgment and directions of the Supreme Court. And all in more detail on the website, which I believe has been linked in the chat now.
Now we can take questions if anybody has any.
I think Vidit had the question. Yes, Vidit, please go ahead.
Yeah, am I audible?
Yeah.
Yeah. Hi guys. Good evening. So I had a question. It's my question is a corollary of what you guys touched upon. It's not explicitly related to the zombie tracker or to data, but it's something Sanjana mentioned while speaking about how you guys went about creating the zombie tracker itself. And it also reflected in another project IFF did with regards to the Anuradha Bhasin judgment, wherein I think you guys wrote to various home affairs departments of various states, and you tried to see whether the judgment was being complied with. So one thing which caught my eye in the latter project was the Meghalaya Home Affairs Department replied with the fact that they simply haven't received a copy of the judgment. Right. So my question would be twofold. Firstly, do you think this approach is valid, that a state can just say can just prima facie say that they haven't received the judgment and it suffices on their part, which I mean I don't, because ignorance of the law shouldn't be an excuse in any case whatsoever. And secondly, do you think there is a system in place so that the Supreme Court can effectively communicate any new decisions which do have a significant impact on law and order and other civil society actors? And if there isn't, then could you guys maybe shed some light on what a system like that may look like? Because you guys do have first-hand experience with research of this sort.
Yeah, maybe I'll begin and then if you guys want to weigh in. On the first question, yeah, I mean, absolutely you're correct. If ignorance of law is not an excuse for, you or me, and we can be prosecuted under anything irrespective of whether we're aware of the law, it seems completely absurd for high courts, for the police, and for functionaries of the state to be unaware of the law. It's actually completely unacceptable. Having said that, I mean, their non-awareness of the law doesn't impact them at all. It only impacts us. So I think in seeking to circulate judgments, etc., we're trying to strengthen the quality of our victories in court. So we're trying to make those victories meaningful. It's a little bit of an aside from what you spoke about, but so Open Society has been studying strategic litigation, and one of the things that they've written about extensively, and it seems to be a problem that doesn't exist so much in the developed world, but they've been studying the impact of strategic litigation in India, in South Africa, in Brazil, etc. And you do see all kinds of innovative remedies being adopted by courts. Sometimes courts make district courts responsible for monitoring. So they may appoint a district court in relevant districts to almost like how in a civil procedure, how you have an execution proceeding where one court will pass a decree and then in execution proceedings and another court will enforce it. It's almost like that, but some systems have evolved systems like that where they've given district courts execution power for constitutional judgments. So that is one way to do it. Whether that will work in a country like India, I don't know. As far as the second question is concerned about the mechanisms we currently have in place, they practically don't exist. There are these yearly summaries of Supreme Court judgments which aren't really directed at authorities. So one of the things that even the zombie tracker paper was talking about, is that in some judgments, you've seen that the court is aware of the signal failure. So for instance, even in Navteej Johar, Justice Nariman talks about the need to disseminate information around Section 377 through news media. Or in DK Basu, which dealt with custodial torture, they required circulars to police, etc., where they're aware of these guidelines. So in some judgments, they pass these very specific directions within the judgment, which requires circulation of the judgment. So in certain cases, you see that the Supreme Court has been aware of the signal failure, and they pass specific directions within the judgment saying that this judgment will be circulated, it will be displayed on notice boards, it will be passed on to police officers and stuff like that. But apart from that, there's no automatic dissemination of Supreme Court judgments. There is, however, training of judicial officers and there's training of police officers. So I think that also is something that needs to be reformed and updated. And that's probably a more systemic, much more long-term issue. Yeah. Anushka, Sonalakshi, if you want to add something to this.
Just add based on the recommendations we have, which are still available on the website. And one of them was how, like you said, the Meghalaya government just said they didn't get it. And one of the things we noticed was at that time, like the Delhi High Court rules, even though the high courts are responsible, as I said, district court jurisdiction, they didn't have any specific rules on how information is to be communicated to these lower courts. We suggested in these recommendations that every district has a public prosecutor that's appointed by the government. So maybe the state government can ensure that this information is disseminated directly to them. They are in the courts day in and day out, and maybe that can help. Another possibility we had was through legal aid cells. If there was some way that maybe legal aid cells in smaller districts could help with the dissemination of this information. And like Sanjana said about training of police force, there is a cybercrime cell that often conducts like sessions for policemen on how to fraud and things related to cybercrime. And one of the suggestions we made was that this cybercrime cell can take the responsibility to disseminate or train police officers on the latest updates from the Supreme Court or other courts to ensure that this information is being passed down. Yeah. Anushka,
Yeah, thank you.
I hope that answers your question with it. Ashna and then Smita.
Yeah, thank you so much for so much giving us so much context on this. So my question is more related to the data mining process. So just from personal experimenting, I've found that often judgments or even orders on district court websites, they're uploaded at random, right? So sometimes even weeks or months after the order was originally passed. And some servers, for example, don't work and they're frequently down. So I was wondering, so since this would pose like huge challenges during data mining, I was wondering how you approach this. Like, did you guys go back to orders later at a later point to check if they've been uploaded, or was there a caveat added in the research methodology that it was a one-time check? So that's one question. And the second question is just in terms of states where you couldn't find enough information on eCourt's websites, did you guys consider RTIs, like filing RTIs? Is that a good process to consider in terms of data mining responses? Yeah.
So with regards to your question about the period, we did put out on the website, if you go to the tracker page, there is an explicit banner on top, which highlights the exact period during which we mine this data. And yeah, like you said, sometimes there is a gap, but just because of the scale of this project, we weren't able to go back. And as Apoorv said, this is something that needs to be done on a day-to-day, like not day-to-day, but like a continuous basis to ensure what's actually happening. And I hope that answers the first question, that we did not go back and we did just focus on that particular period until I think the 15th of Feb 2020 is where we cut off date. And I think with the second question about RTI, Anushka might be able to answer it better, but we did file a few and we didn't really get information from that. But I think Anushka can add more to that.
No, actually, sadly, we did file RTIs and we did try to get information in that situation as well. And it was not for states that we did not find information for. We just stuck to the 11 states, and then so firstly we had 7 states, then we couldn't find much information, and then we decided to also include 4 more states where we thought cases might be more. When we faced this glitch, we also tried to file RTIs and get the information in that situation. But with RTIs also, you have to know that information that the public information officer or the central public information officer will share with you, there is only a certain limit to which you can push that person. So if they have that information readily available, they might send it to you. If it's one of the questions in multiple questions, they might make an effort because they've already answered so many questions. But if you ask them to collate data basically for you, which is what we ask them to do, they will not do it. And this is under the provisions of the RTI Act. They just refuse to do this. So we couldn't get any information from the RTI Act, even though we did try that route. I hope that answers your question.
Yes, yes. Thank you. Thanks so much.
Yeah, just on the first question, just wanted to add a point. So, Asma, if you see the tracker, so whatever you see there, I think we are not. It is only created using the metadata which is available on eCode, like most of it, all of it actually. So the only one thing we used the judgments for, and where we like really needed the judgments, was like when we were not sure whether a case was 66A or not, because it was not written in a standard way. So then we had, especially when it was disposed, so we thought of maybe checking the judgments to see what whether we can confirm whether it's a 66A or not. So that is one kind of use case where we needed the judgment. But if you see, for all the other things that we are doing on the platform or showcasing on the platform, it is all through the metadata. So just imagine if we are able to get access to the judgments, what all we can do. Like we can really go to the root cause, and we are just touching the surface right now. So I just wanted to share that.
Right. Yeah. Thank you. Thanks so much.
Smita, please go ahead. Yes.
Yeah, hi. So my question actually relates to what Ashna just spoke about. But first of all, before I start, thank you so much for giving us so much context and so much information on the tracker itself. I had no idea personally, and I'm surprised that I didn't, but thank you for telling us. So my question relates to the e-codes. Because in my previous internship experiences, I'm still in law school, particularly WWF India. Over there, I was collating data on Uttarakhand's district court's website. So for instance, Dehradun court on particularly the Wildlife Protection Act of 1972. Now, while doing that, I faced many of the same issues that you also faced, like some of the examples that you wrote in the chat. And that got me thinking that, and I think somebody else mentioned in the conversation just before that ignorance of law is no excuse. So I was just wondering that if people, if citizens, if law students, they themselves don't even know what cases exist, how are we supposed to even track their applicability or their compliance or follow them? Because SCC Online, Manupatra, etc., they're all paid services. Not everybody, once I'm out of law school, in 1 month's time, I will not have access to all of that. And that really scares me, because a lot of my legal research abilities depend on a paid subscription service that I cannot afford. So in light of that, I understand that you have made recommendations and sent a letter to Justice Chandrachud, if I'm not wrong. But what else do you think, or what else would you suggest that we can do as a community of law students, or as just like aware citizens? Because this, I think, really directly impacts our constitutional rights as well. So this is just like for conversational sake, like if you have some insight that you could provide. Thank you.
I'll go. I think I personally honestly find Indian Kanun also really useful. Also because like it loads faster if you're like, on your way to court and stuff like that. The issue, however, is that a lot of judges, and I feel like that's really elitist gatekeeping more than anything else. A lot of judges don't appreciate Indian Kanun copies. So in the High Court, you see that the Indian Kanun copies are cited and people are okay with it depending on the judge. The Supreme Court gatekeeps this very particularly. And for some reason, they prefer SCC copies, even though the SCC is not the official Supreme Court reporter. The official Supreme Court reporter is SCR. I'm also aware that there have been attempts made to backdate and keep all copies of SCR online. They started doing this process. So I think they covered 2000 to 2008 or 9, and then they kind of stopped. So there have been letters, I think one of them was published on Live Law also, requesting the registry to make all copies of SCR available, but that digitization, obviously all of them exist in the Supreme Court library, but that digitization unfortunately has not been done. I think there has been an effort made to start digitizing High Court judgments, and also in formats which are disability inclusive, so formats which can be read by screen readers, etc. So there is now some attempt to standardize the manner in which High Court judgments are reported / accessible online. But I think eventually the solution would be that at least for constitutional courts, like all High Courts and the Supreme Court, you should ideally have one database that's on the Supreme Court website with like links on the High Court websites. I mean, there's really no good reason why that shouldn't exist. In fact, in other countries, you see that going so much farther. Like, for example, Canada realized the issue of broken hyperlinks, where like if judgments have links, sometimes later those websites no longer exist. So they've started archiving all links cited in all Supreme Court judgments since forever. Since they've started using hyperlinks. So there's a lot of effort in other jurisdictions to ensure posterity of these judgments when someone accesses them later. But somehow we have not done that systemically. So I think it just, the advice right now is to try and use things like Indian Kanun. But I mean, for official citation, you will be forced into SCC. And let's hope that changes over the next 5 to 10 years. Yeah.
All right, thanks. I think that's very hopeful, and I really hope that that does happen like soon. Like I hope before 5 years, because I don't know how we're going to manage otherwise. I think Indian Kanun has been really like, even in law school, like I don't think that was ever considered like a legitimate source. I don't know why, but ever since first year, like it was never considered like a legitimate source. So I guess that's elitist, yeah.
Any other questions?
While other folks ask question, and again, like this is not related to zombie tracker again, but I just wanted to, and this is more for like my learning process, like what is this gatekeeping like, business, like how do you like sort of validate, what sources, and is there like a rationale, is there a rubric to say that, if these are the conditions met, then that's like a credible source? Like how do courts and, other legal bodies sort of like validate what sources you can refer to in a case?
So I should also clarify, since I've mentioned Indian Kanun, like our conflict of interest is that we have appeared for them also. But apart from that, like whatever these open source things are, there's a procedure to apply to the Supreme Court to become a reporter. It's not a complicated procedure, but it involves some fee, etc. And SCC has been doing that. Another thing is that SCC has just been doing it for so many years that the Supreme Court library has copies of the SCC. So for instance, every courtroom in the Supreme Court, if any of you have had the chance to visit in internships, has SCC copies lined from some year to some year. Plus they supply different things. So, practically when you're arguing before the Supreme Court, in the High Court, what happens is you give them copies of what you have. So if you're carrying an Indian Kanun, then they will also, I mean, you print one copy for yourself and you print one copy for the bench is the standard practice when we're arguing before the High Court. In the Supreme Court, what happens is the standard practice is to give a list of books. So like on a chick, you write the SCC citations and give it to the court master and he'll pull out those books. So interestingly, obviously you can't copyright judgments because the judgments written by the Supreme Court. But what SCC has copyright over is its formatting. So the para numbers in an SCC are different from the para numbers in the official Supreme Court reporting. So if I am reading from Indian Kanun, the issue that I'll face with SCC is if the judge is looking at para 4, that's maybe para 10 in my thing. So, just to, while arguing, there is that difference. So Supreme Court judges have a tendency to prefer SCC as a result. It's strange because they don't really prefer SCR, but I feel like SCR access is poor. So SCC started around 1955, 56. So you have people using AIR and using SCR before that. But as soon as SCC has come in, like I think the monopoly is so extreme that all lawyers have SCC copies. The Supreme Court has printed SCC editions. So because of just this para number distinction, which feels really arbitrary and random, because of that, you're forced into using SCC. Yeah.
So Sanjana is clarifying. So basically you're saying, so when a judgment comes out, obviously it's coming out from the Supreme Court. So then SCC takes it and formats it in its own way, and then the Supreme Court is using that instead of using the original one.
In a sense, yeah. So the thing is, the original one is what you see in the judgment copy. So if you go to the SC website and you click on judgments and you put the case number, you see that original. So for example, like as soon as the Aadhaar judgment came out, there is a copy that is circulated. That is the official uploaded, so what you see on Live Law, what you see carried in news articles, etc. That is the official Supreme Court copy of the judgment. Supreme Court reporters generally publish them in quarterly or annual or whatever their mode of SCC, I think, publishes 12 to sometimes even 16 copies in a year, depending on the volume of cases. So it won't come out immediately, but SCC releases a newsletter every 2 weeks, which then get compiled to form the volume. So like SCC will reformat the judgment. They'll write a head note, which also I've often seen law students rely on incorrectly. It's not the official head note. The SCR has a head note which is approved by the Supreme Court, but the SCC head note is written by people who work at SCC. In fact, I think Manu Patra gets its head notes written from law students, if I remember correctly, because at least when I was in law school, they used to be on the lookout for law interns. But SCC site takes the judgment, they format it nicely, they add their own head notes. And for example, if you see in Shreya Singhal, they have like summaries of the arguments of all the counsels. So they've reached out to them and gotten copies of the written submissions. So they just do these tiny changes. But after that, yeah, there's a tendency then to rely on the SCC citation. Yeah.
Wow. I think we have another question by Soumya, and also we are timed, so you guys are fine extending it by 5 minutes, and we can take this as one of the last questions. Cool. Soumya, please go for it.
It wasn't a question so much as a comment. So to Apoor, the distinctions about what makes SCC so super special, such a special little snowflake is there in Eastern Book Company versus DB Modak. So I studied that while
Soumya, you're not very clear. Can you come closer to your mic?
Yeah, am I audible now?
Yeah.
Okay, so what makes SCC so special, what they have copyright on is there in Eastern Book Company versus DB Modak. But what I want to ask the everyone present here is like, there are some free databases like LegitQuest and CaseMind which you can apply for as a student. So like maybe you could use those. And Legit Quest for one, I think at least has a much wider coverage of judgments than SCC as well, even, or even Manupatra for that matter. So that's about it.
Cool. Thank you for sharing that, Samya. Is there any other question from anyone? Do they cover the district courts as well? Apurv, is that question? Okay, that's first Samya. I'll let it go. Anyone else? Any other question? I guess that's about it. Yeah, wow. This was quite a session. I'm like I'm still processing all of that happened in this 1 hour. Like the whole story of like zombie tracker, legal authorities not being aware of what has been passed as like as a rule and an order. This all just like seems like a brilliant like Bollywood movie where the mistake has happened and now the protagonist is like just chasing the code of law to get justice. But thank you so much for taking out time, Anushka, Sanjana, and I think uh, so is your teammate left?
Sonalakshi, yeah,
Sonalakshi,
she's here.
sorry, Sonalakshi, has she dropped off?
No, she's here.
Oh, she's here. Oh, okay, awesome. Because I was not able to see her on the gallery, that's why. Anyway, so thank you so much, all of you, to join us this evening and have an interaction with Summer of Data students. What they are currently occupied with is collecting a lot of data on the background of judges across high courts in India, and we hope to come out with the unique data set that they have all put together at the end of 5 weeks. So we will keep you guys posted, and this was really inspirational personally for me, and I speak for all of us, like for all of us in terms of like the role that law and data can play in the law and justice space. So yeah, once again, thank you so much for taking out time, and yeah, have a great weekend, great evening. Thank you so much.
Thank you for having us. And also, I want to specifically thank Sonalakshi, who was working for us specifically for this project. And she took out time and came here today to talk about it because she was one of the most integral parts of the project, as well as obviously Sanjana. So yes, thank you for having us. And I hope you guys had fun. I hope you guys learned something new. And I hope this is the best Summer of Data session that is there. That's just a thing that I want personally. But yeah, thank you guys. Bye bye.
Awesome. Thank you. Bye.
Thank you for having us. Bye.